How many times do we all hear this hackneyed, cliched line? They would say, oh, the three branches of government, they're separate but equal. Separate but equal. I vividly recall that. I'm sure you do too. There's only one problem. It's not true. It's absolutely not true. A republic, if you can keep it, famously said Benjamin Franklin when asked by a doctor in Philadelphia what form of government the wise men at the Constitutional Convention had given these new United States in 1787. What is a republic? Who fundamentally decides the most important questions facing the citizenry? This is a self-governing form of government. It is not a government of, by, and for the elites. It is not a form of government here in this country of, by, and for the juristocracy. It is not a form of government of, by, and for the privileged. It is a form of government of, by, and for the people. As Abraham Lincoln famously put it in perhaps his most famous speech, the Gettysburg Address of 1863. Part and parcel of this understanding of a republic, if you can keep it, as Franklin famously said, is a separation of powers that understands the separate roles of Article 1, the Congress, Article 2, the executive branch, and Article 3, the judiciary. How many times growing up, I think back to when I was in middle school, in high school, how many times do we all hear this hackneyed, cliched line? They would say, oh, the three branches of government, they're separate but equal. Separate but equal. I vividly recall that. I'm sure you do too. There's only one problem. It's not true. It's absolutely not true. How do I know it's not true? Because the Founding Fathers said as much. Alexander Hamilton, Federalist number 78, one of my absolute personal favorite of the Founding Fathers. One of the most important of the Federalist Papers. Federalist Papers, this remarkable series of over 80 essays written pseudonymously, using anonymous names. We subsequently found out that it was James Madison, John Jay, and Alexander Hamilton trying to persuade the people to adopt the Constitution. You know, back once upon a time when we actually decided these things not with assassin's bullets, not with rifles, but with the pen. Hamilton, Federalist 78, famously says, the judiciary is the least dangerous of the three branches because it has neither force nor will, but merely judgment. And moreover, it depends upon the efficacy of the executive branch even for the enforcement of its own judgments. They are not even equipped, these black-robed oracles, sitting in their judicial chambers. They are not even equipped to enforce their own judgments once they make them. Think about that for a second there. If a judge issues a ruling there, you in what army? President Andrew Jackson, one of President Donald Trump's favorite presidents because of his staunch populism, his standing with the American people against commercial and cultural elites. Andrew Jackson famously put this to Chief Justice John Marshall in one of the Indian removal cases. The popular line is that Jackson said to Marshall, John Marshall has made his decision, now let him enforce it. The actual quote's a little more complicated. Jackson says, the court has made its decision, they have seen that it has fallen on stillborn ears, or something like that. But the point stands. They can't even enforce their own judgments. The greatest statesmen in American history have understood this. Abraham Lincoln, my personal favorite in all of American history. Abraham Lincoln understood this better than anyone. In 1857, the U.S. Supreme Court decides the single worst case in the history of that most eminent tribunal, the Dred Scott case. Dred Scott involved a former slave named Dred Scott from the state of Missouri. And in a monstrous, a legally and morally abominable ruling, Chief Justice Roger Taney, a virulent racist, holds for the majority court that black people were not and could never be citizens of the United States. The following year, in 1858, Abraham Lincoln is challenging Stephen Douglas for U.S. Senate in Illinois. This is how you get the Lincoln-Douglas debates. They go all up and down the prairie state debating lots of topics. The hot topic at that time as you can imagine, was the peculiar institution, the institution of chattel slavery, and specifically the expansion of slavery westward into the territories. And the number one issue that Lincoln and Douglas debated over and over and over again throughout those debates was the scope of the binding nature of the Dred Scott decision the year prior. Douglas was of the opinion that you would have to be a tyrant. You would have to be a dictator to call into question the United States Supreme Court. Who are you to call into question, to impugn the legitimacy of a 5-4 decision, a 6-3 decision, an 8-1, 9-0, whatever it is? Rather, what Douglas said is that the question of slavery in the territory should be that of popular sovereignty, of up and down, majority vote, free state, slave state, so be it. But Lincoln said no. He said no on both grounds. He said no to the majoritarian question because there were some questions, Lincoln said, that are simply not fit for majoritarian thumbs up, thumbs down votes. There are some questions that are so fundamental to substantive justice, to morality, to the transcendental order of humanity, of this notion rooted in Genesis chapter 1, verse 27, that man is made in the image of God, that we are in us. There's a spark of the divine, and therefore we all truly are the children of God and entitled to inherent moral worth and respect. Lincoln understood that there are some things you cannot subject to an up-down vote. But even more to the point for present purposes, Lincoln understood, as he reiterated in his 1861 first inaugural address, that he who yields to a bare 5-4 majority of the U.S. Supreme Court, and that is going to be the end-all, be-all, the final arbiter of all legal, constitutional, political, perhaps even moral questions in these United States. At that point, Lincoln argued, the people will have ceased to be their own rulers. They will allow that most eminent tribunal, the 9 justices of the U.S. Supreme Court, to rule this country in a grand act of juristocracy, judicial tyranny by any other name. And throughout his presidency, that's what Lincoln did. He issued passports to blacks in the western territories of the United States in direct contravention of the Dred Scott decision. At some point in the middle of the 20th century, the American people's relationship, their social contract, their understanding, their covenant, you might say, with the Supreme Court fundamentally starts to change. First, you have the FDR presidency and the New Deal. FDR is really trying quite quickly and aggressively to get past his New Deal legislation, this remarkable, hitherto unprecedented expansion of the administrative state to apply various congressional statutes and constitutional provisions to places they had never been before, to reach areas of your private life, of your commerce, of your conduct, of your day-to-day being that they never touched before. And he threatened to pack the court to get his way when you had the so-called 4 horsemen, the 4 conservative justices, who stood in his way. And rather than risk having a packed court, there was the so-called switch in time that saved 9, where when the 4 horsemen switches to the left and FDR has his pro-New Deal majority. That begins what we would call judicial supremacy. That begins the modern judicial supremacist movement. The notion that the judiciary is not, as Hamilton told us in the Federalist Papers, the least dangerous of the 3 branches, but is actually, indeed, the sole, final, and exclusive and binding arbiter of this nation's legal, constitutional, political, and moral disputes. That understanding was accentuated, indeed it was exacerbated, roughly 2 decades after FDR's heavy-handed quasi-tyranny led to the switch in time that saved 9 and solidified the pro-New Deal court. In 1954, you have the case Brown versus Board of Education, an unambiguously righteous case, school desegregation. The aftermath of Brown, though, saw mass resistance. Think about a recent controversy in current events. President Trump trying to send in the National Guard to cities and jurisdictions there. Well, we had this debate back in the 1950s, too. You've probably seen the Norman Rockefeller paintings of Dwight D. Eisenhower sending in the National Guard to Little Rock, Arkansas. And who was standing there in the doorway to block it? The governor of Arkansas, Orville Faubus. So amidst the specific context of school desegregation, the Warren Court, a very liberal court, which nonetheless had indeed ruled correctly in the Brown versus Board of Education case, the Warren Court seizes upon this unique circumstance to take a dramatically opportunistic fashion, a dramatically opportunistic action. And what they did, in a somewhat obscure case from the late 1950s, you probably never even heard of, called Cooper versus Aaron. In the context of this righteous crusade to desegregate the schools of the Jim Crow South, the court then seizes the opportunity to tangentially and opportunistically assert that only they control constitutional interpretation in this country, that the executive branch must yield, that the congressional branch, Article 1, must yield. No longer, the Cooper versus Aaron court said, are we to be in a separation of powers construct that the framers devised. No longer will we be in a situation where the executive branch can, indeed should, interpret and enforce the Constitution according to their own interpretive abilities. No longer, similarly, would we be in a situation where the Congress, senators and congressmen, can interpret the Constitution to their own abilities. Rather, in this post-New Deal, post-Cooper versus Aaron court, judicial supremacy rules the roost. And what judges say is the law of the land. There is one glaring problem with judicial supremacy. Perhaps more than one, but we'll focus on one. It is antithetical to the form of government the Founding Fathers gave us. The framers, yes, were absolutely concerned with majoritarianism run amok. They would have been very, very, very skeptical of Stephen Douglas's appeal to popular sovereignty when it comes to the most foundational questions affecting human anthropology, slavery, sexuality, the most basic questions of who we are and what we're doing in this realm. They also, though, were deeply skeptical of various forms of tyranny. They had just fought a war against King George III to get independence from the British crown. Do you think for a second that they were about to subject themselves to a different form of despotism, to a judicial tyranny? No! They had no interest in that whatsoever. None. None. It was not long thereafter, after the Cooper versus Aaron case of 1958, that you had the rise, slowly at first, slowly and then suddenly, as the popular line goes, of the so-called nationwide injunction, including from lower court judges. The first use of one of these so-called nationwide injunctions arises, indeed, in the late 1960s, roughly a decade, give or take, after the Cooper versus Aaron assertion of judicial supremacism. The purported nationwide injunction, universal injunction, the two names are synonymous, is the alleged ability of, yes, the U.S. Supreme Court, but also, they say, lower court judges, appellate judges, federal district court judges, to issue a ruling that will bind not merely the named parties to the suit, not merely even the district wherein that judge resides and presides, but rather the entirety of the body politic, the entirety of this great nation from sea to shining sea. But that is not what the judicial power stands for. When the framers were devising the least dangerous branch, Article 3, they refer to the judicial power. Well, the judicial power was a term of art. It referred to the ability of a judge to issue a binding judgment as pertains to the named parties to a lawsuit. If Smith sues Jones, a judge issues a ruling that binds Smith and Jones. Thompson, a third party, is not affected by that. At some point, the federal judiciary mistook this basic element of not just constitutional interpretation, but frankly of basic English language semantics. The nationwide injunction was launched in the late 1960s. It really starts to take off, though, during the first Trump presidency, from 2017 to 2021. Over the course of that 4-year term, President Trump's first term, there were between 60 and 70 issuances of so-called nationwide injunctions. That is more than the first 44 presidents combined. In a 2018 case called Trump versus Hawaii, this was the litigation pertaining to the old travel ban, a misleading name, but when President Trump said that we're going to severely limit, if not outright eliminate travel from certain terrorist-prone countries, I think 5 were in the initial order. Case gets all the way to the U.S. Supreme Court, and to their credit, the justices ruled correctly. Chief Justice John Roberts, a mercurial Chief Justice if there ever were one, has a pretty darn good opinion in that case. Clarence Thomas has a concurring opinion where he says, this whole nationwide injunction thing, it's getting a little out of hand. We're really going to have to come back and try to root this out unless the judges just end it themselves. That hasn't happened, though, has it? Because in this first year of the second Trump term to date, there have been so many issuances of these so-called nationwide injunctions, judicial injunctions, all across this country. By the end of this first year, they are going to surpass the entire total of the 4 years of the first Trump term. By some metrics, they already have. It's just a question of how exactly you count it. They're stopping President Trump on everything. You remember Judge Boasberg in D.C. literally telling President Trump to turn the plane around? The plane heading down to El Salvador? Turn that thing around midair? They're encroaching him when it comes to immigration enforcement. They're encroaching on him when it comes to the National Guard. This is not just judicial activism, folks. This is, as I've been saying for months now, this is a judicial insurrection. This is a judicial insurrection, the likes of which this country has not seen since Abraham Lincoln himself was president and Chief Justice Roger Taney, the virulent racist, was trying to gum up the works every way imaginable. We even had a favorable ruling in late June at the Supreme Court in a case called CASA. This was referred to as the birthright citizenship case, but the actual oral argument was not really about the actual substantive 14th Amendment question of birthright citizenship. Rather, it was about the scope of the binding authority of the courts, namely this question as to the legitimacy or lack thereof of so-called nationwide injunctions. In the CASA case, you had Amy Coney Barrett, who I've actually been pretty skeptical of at times. She had, I would say by far, her most shining moment to date. It wasn't perfect. There was a little bit of lawyerly wiggle room language in there. But by and large, in the CASA case, just a few months ago, back in late June, Amy Coney Barrett says that there's a strong rebuttable presumption, meaning that we presume that a judge does not have the authority to issue a so-called nationwide injunction. That hasn't stopped them, though. On the one hand, you have a lot of judges in the lower courts who are now abusing an entirely separate judicial tool at their disposal, the class action lawsuit tool, Rule 23 in the Federal Rules of Civil Procedure. They are abusing their discretion there to grant these massive, sprawling, purported classes of would-be plaintiffs who share virtually nothing in common with one another, other than they happen to hate the same defendant and want to get some damages. Is a long-standing debate is how to discern what is a legitimate class. The left is winning on this question. We saw it coming. Many of us did. That will be the next battle in our judicial power wars. But many of them are just not stopping in general when it comes to issuing these sprawling injunctions. In June, around the time of that case, the Casa case, there was an anarchic anti-ICE uprising out in California, out in the City of Angels in Los Angeles. You had Justice Stephen Breyer's brother, Judge Breyer, who issued a farcical ruling telling President Trump that he could not send in the National Guard to quell this anti-ICE, pro-anarchy, Antifa, Black Lives Matter-inspired uprising out in Los Angeles. Judge Breyer's ruling was subsequently overturned by the United States Supreme Court. Correctly, because President Trump has the clear statutory authority under an 1807 law called the Insurrection Act to call up and to deploy the National Guard when there is legitimate anarchy, when there is a legitimate breakdown of law and order, when there is a legitimate breakdown of the public trust, of peace, etc., at the local level. That statute, the Insurrection Act, goes back to the Jefferson presidency. It is bread and butter, it is part and parcel of the American tradition. Oh, you can't send in the military, the left claims. Well, kind of true. There's another law from the late 1800s called the Posse Comitatus Act in the 1870s that, yeah, you can't actually send in active duty troops except in most extreme situations imaginable. But we're not talking about that. We're not talking about sending in the 101st Airborne. We're not talking about sending in SEAL Team 6 to a bunch of pink-haired hippie weirdos. You know, we're not talking about sending in a bunch of Green Berets to round up the Marxist harpies or the transgender genital mutilators. No, we're talking about sending in the National Guard where there is legitimate anarchy. And even then, the left recently has found itself unable to abide by superior courts. Think about what happened fairly recently in Portland, Oregon. Another breakdown where the Portland police utterly refuses to safeguard, to keep watch over a federal building amidst the metastasis of these anti-ICE, anti-immigration, law enforcement, pro-open borders insurrectionists. And a judge, scandalously, actually a Trump-appointed judge, someone who was clearly a compromise pick with the state's Democratic senators through the blue slit process. It was actually a Trump-winning judge, though, who basically questioned President Trump and said, wait, time out. There's been like 3 maybe times where you couldn't actually get local enforcement there. You don't need the National Guard. Forget it. Well, one, who the heck are you to say that? Not your role. 2, just as important, we just had this same conversation out in California, out in June. Are y'all not capable of listening to your superiors? Is that not an act of mini insurrection in and of itself, where a lower court judge just refuses to listen to the U.S. Supreme Court? We saw that with Judge Murphy in a totally separate case in Massachusetts earlier this year, too. But overall, you are looking here at a first year of this first term, that sadly, tragically, has been marred, has been undermined by a sprawling, subversive federal judiciary. The administration is fighting back with their tools at their disposal. They have some work, certainly, left to do. Among the things that President Trump is trying to do admirably, and we've had numerous court cases on this, is try to reconstitute the executive power of Article 2 and really presidential power in earnest. The executive power of Article 2, which establishes the executive branch and the presidency, says the executive power shall be vested in the President of the United States. That's one person. The executive power is not vested in the vice president. It's not vested in the attorney general, the secretary of the treasury. It's not vested in the coffee boy, the dog catcher, or me, or you, or anyone else. It's vested in one person and one person only. That is POTUS. What does the executive power mean, if nothing else? If you're an executive, it means that you have the ability to control your own organization. You make hiring decisions, you make firing decisions, you call the personnel shots. You're hired, you're fired, get the heck out of here, come on in the door, goodbye, hello, etc. If you are a purported CEO of a private company and you don't ultimately have veto power at minimum over hiring and firing decisions, then you are a CEO in name only. You're not a real CEO. So too, you are a POTUS in name only if you don't have control over your own executive branch. There have been numerous instances of this first year, holding aside the bread and butter judicial insurrection bucket of cases dealing with immigration. There have been a whole bunch of other cases dealing with core Article 2 presidential power that Donald Trump is trying to reassert and reconstitutionalize. Among other things, he's tried to fire members of the FTC, the Federal Trade Commission, that he doesn't want serving there. Let's go ahead and take a listen to Andrew Ferguson, the brilliant chairman of the FTC, explaining this legal battle recently on television. Go ahead and take a listen.
I don't want to have the FTC like it was for the past 4 years, where deals would come into the agency, they would disappear, no one understood what was going on, and it sure seemed like a lot of times the FTC was hoping that deals would sort of die on the vine without any official action. If they're anti-competitive, we'll go to court. If we're not, we're going to get out of the way, and we're going to let the economy grow for all Americans.
Very great points. Very well said. Mr. Chairman, before you go, do you see an increase of sort of those deals that were on the shelf, coming off the shelf for your review at this point?
We've seen a pickup in deal activity, especially right in February, and we'll see if that continues. The FTC is ready for whatever comes, but again, my main goal is regulatory certainty and clarity. If a deal's anti-competitive, we're going to be honest with the business community and say, look, we're going to have to go to court on this, and if it's not, we're getting out of the way. We've granted early terminations of deals to allow them to close early. The previous administration was refusing to do that. We've already brought that back, and we're already seeing improvements in the process at the FTC under President Trump.
So Chairman Ferguson, first of all, absolutely brilliant pick. Former Supreme Court clerk, one of the most brilliant legal minds currently serving in the administration, one of the most brilliant legal minds that you probably are more likely than not to have never heard of. He's talking here about numerous things, but the FTC was founded back in the 1930s as an independent agency as part of this whole New Deal FDR social contract there. So too with the National Labor Relations Board and various other agencies there. These so-called independent agencies are constituted via partisan nominees. So the president can appoint certain Democrats, Republicans, and typically there's a provision for these so-called independent agencies that one of the commissioners can only be fired for cause. For cause. That's the case for the FTC. That's the case for the National Labor Relations Board, which is a very similar litigation case called Wilcox versus Trump, where Trump has tried to fire a Democratic Biden-nominated commissioner named Gwen Wilcox. There was a case from the 1930s called Humphrey's Executor, a case that, frankly, I read in law school. I was like, there's no way this is correct. This case said that, yes, these for-cause removal restrictions are legitimate. That it is okay. It is constitutionally permissible for Congress to implement a restriction whereby a commissioner can only be removed for a cause, and that is not an infringement on the executive power of Article 2. Except there's one problem. It literally is exactly that. It literally is an infringement on Article 2. Again, you either call the shots as the executive or you don't. The alternative is this notion that maybe the FTC, maybe the National Labor Relations Board, is not actually part of Article 2. In which case, where is it? Is it part of the Congress? Is it part of the Judiciary? Another very interesting, somewhat related example is the recent dispute over the Federal Reserve. Lisa Cook, on the Board of Governors of the Federal Reserve, Donald Trump's been trying to fire her over alleged, and it really looks like it really is, mortgage fraud. A very, very interesting debate. Pocahontas, Elizabeth Warren from the Communist Commonwealth of Massachusetts, she's got some strong thoughts on this one. Let's go ahead and take a listen.
These are allegations, and where did they come from? They came from a Donald Trump lackey who said, in effect, I have access to a whole bunch of data that nobody else sees, and let me see if I can go through the Donald Trump enemies list and find anything that I can claim is dirt that you might be able to use to lever somebody else. That's this process that's been going on so far. What I care most about is that we follow the law here. And the law is pretty clear that firing for cause means job related, like someone who has been inefficient or someone who's been corrupt in doing the job.
Except there's one problem, Pocahontas. If that's what Congress meant, they would have put it in the statute. If Congress meant that the only way to fire a Federal Reserve governor, the only way to fire an FTC commissioner, anyone, was if you were actually indicted or actually convicted of a crime, or you actually had pink hair or whatever, they would have written that. You know, contrary to popular belief, Congress is not necessarily a bunch of dimwits. When they want to write something, they're fully capable, or at least their lawyers are fully capable, of actually writing it. There is no need to read into a law Congress has written more than what it says. So the natural reading of a for-cause restriction should be read against the background rule that all of this is highly constitutionally dubious in the first place, for the very simple reason, again, that the executive power means you fire and you hire. Congress meddling in this area in general is a problem. Oh, but the Federal Reserve is different, they say. Is it, though? Well, true, the court did say as much in a very terse two-page order back in May in the Gwynne Wilcox case, the National Labor Relations Board case. They did say that, yes, the Federal Reserve's a little different there. And there is a history of central banks being treated differently, going back to Andrew Jackson's wars with the second bank of the United States there. That history a little bit neither here nor there for present purposes. But what is here for present purposes is this. The Federal Reserve describes itself on its own website as an agency of the government. If it is an agency of the government, if it is not a private bank, like a JP Morgan Chase, a Goldman Sachs, Morgan Stanley, if it is a government agency, which it is both because I see it, you see it, and they literally describe themselves that way, then the question naturally arises, where are you? Are you in Article 1 of the Congress? Are you in Article 2 of the Executive Branch? Article 3 of the Judiciary? If you're not in Article 1, you're not in Article 3, you're not in Article 2, you're not anywhere at all. You're in 1, 2, and 3, or you're in no man's land. And no man's land is not a good place to be. You're done. You're not a part of the government at that point. This is a part of the law where I'm actually quite optimistic about this current court. The current court has some weaker-kneed Republican nominees. No doubt about that. The reality is there are only two justices on the current court, Clarence Thomas and Sam Alito, who are rock solid case in and case out. Neil Gorsuch is consistently good for the most part, with a handful of types of cases where he's not. Immigration law, American Indian law, transgenderism, that's the infamous Bostock case 2020 there. Brett Kavanaugh, Amy Coney Barrett, John Roberts, somewhere in the murky middle. But if there is one area where this court has been quite good, it really is in the area of bread and butter constitutional structure. That, for instance, is how you got a strong 6-3 majority and a really strong Amy Coney Barrett opinion in that Kasich case discussed earlier in the show. That was the case that said that nationwide injunctions are presumed to be unconstitutional unless ... XYZ provisions are affirmed. So I'm actually optimistic that in this coming Supreme Court term, we're going to get some good rulings, some good jurisprudence when it comes to reaffirming, reconstitutionalizing the executive power of which Article 2 speaks. I think Trump's going to get his way when it comes to the FTC. I think he's going to get his way when it comes to Gwynne Wilcox on the NLRB. I think he's going to get his way when it comes to Lisa Cook out of the Federal Reserve. Is that tyranny? No. Is that fascism? No. Is that a dictatorship? No. That's literally the executive power. You don't like it, take it up with the founders. Another area where this court is actually on really solid ground is the area of free speech. I struggle to think of a single time in recent years where this court has not upheld a maximalist conception of free speech. They are really, really hardcore, that is to say, on free speech, and they are really, really hardcore on religious liberty. They have been really, really good on both these issues for at least the better part of the past decade. The same-sex marriage case, 2015, a little bit of an asterisk. The Bostock case, the transgender case, 2020, a little bit of an asterisk. But for the most part, they've been really solid on both of these areas. Well, that takes us to one of these marquee culture war cases for this coming Supreme Court term. A case out of Colorado called Childs versus Salazar. Childs versus Salazar. This is a case involving so-called conversion therapy. And it's banned. So-called conversion therapy, where the parents want to speak to the children that they are not homosexuals, even though they think they are, that they are not transgenders, even though they think they are. Colorado is trying to ban it. But can they actually ban it? Can the state actually ban a parent from talking to his or her child, or bring in a third party to talk to his or her child about that which the parent wants to do? No, of course not. If the First Amendment entails literally anything at all, it entails two specific things. One, it entails political speech. Political speech is the sine qua non, the crux of the First Amendment's free speech protection. Period, full stop, end of story. It is there. Think back to Thomas Paine in the Philadelphia Commons, handing out his pamphlet of common sense back in 1776. That is the crux of the free speech clause of the First Amendment. The other crux is that parents have the ability to dictate the upbringing of their children, including in this context when it comes to free speech issues. The notion that a state can just come in there and swoop and say you're not allowed to discuss certain things because your religion is inherently bigoted, your worldview is bigoted there. You and what army? This country is founded not just on constitutional free speech values, etc. It was also founded on godly values, on biblical values. Even someone like Thomas Jefferson, a theologically heterodox man would be a polite way to put it. Someone who famously literally tore out the pages of his Bible's New Testament. He had no interest in alleged miracles. He was not an Orthodox Christian by any stretch of the imagination. Even he felt compelled in the Declaration of Independence of 1776 to appeal to God-given rights, to life, liberty, and the pursuit of happiness. Because this country was founded as a bastion of biblical values and godly values. There is no way that this Childs versus Salazar case out of Colorado comes out anything other than the correct way as well. By the way, just as an aside, I mean, I say on the one hand facetiously, on the other hand seriously, what are they smoking out in Colorado? I mean, I know, Colorado, first state to legalize marijuana. Trust me, I lived there for a year. I get it. The whole place stinks like weed. But, I mean, all these culture war cases, the Salazar case involving conversion therapy, Jack Phillips, poor Mr. Phillips of Masterpiece Cake Shop, the Bake the Darn Cake Bigot case, that's out of suburban Denver and Colorado. The 303 Creative case, a massive free speech case a few terms ago when it comes to a Christian marriage website designer, also out of Colorado. I don't know what they're doing in Colorado there. It ain't good. The good news is that this case, mark my words, I'm pretty sure it's going to come out the right way. A case that I'm not sure is going to come out the right way, if I'm being brutally honest, the tariffs case. The whole legality of Donald Trump's tariffs coming into question ASAP. Here's Donald Trump talking about it.
The trade deficit in half, is that right? That's a fantastic. I didn't even think we were going to do that. And remember, these are things that are being built. These things are, all these numbers up here, they're not open yet. When they open, you're going to see things happen in the United States that nobody's ever seen before, including our country in its heyday. And I had the greatest economy in the history of our country my first 4 years.
So there is a big case coming up here out of the U.S. Court of Appeals for the Federal Circuit, the constitutionality of the tariffs. Basically, it goes back to a 1970s era statute. Is this a sufficient emergency? The trade imbalance, the balance of trade that allows President Trump to issue a lot of these tariffs unilaterally without congressional authorization. It's a very interesting, close legal question. I do not know the answer. I do not know what this court's going to do. The appeals court wrote their decision in a way that really is directly playing to the Brett Kavanaughs, the Amy Coney Barretts, the median Republican-nominated justices of the world. How will they rule? Frankly, your guess is as good as mine. But overall, surveying the landscape there is a lot of good opportunity for the Supreme Court to continue the overall positive momentum. The real question that I have over this next year of this Trump term, and I've been asking this since day one, is holding the Supreme Court aside, is this administration prepared? Do they have what it takes especially, God willing, working with Mike Johnson, John Thune, and a helpful Congress? Do they have what it takes to not just rely on the courts, but to do all they can on their own with their own authority, whether it's executive, legislative, or some combination thereof, to stop this historical judicial insurrection and just crush it? Crush it. I don't know the answer. But the hearts and minds of patriots are paying closer attention to this particular question, I know, than ever, ever before. Because as we said at the beginning, this country really is a republic only if you can keep it. Judicial supremacy, juristocracy, judicial insurrection is not keeping this republic, unfortunately.